negative about certain groups, and some points mocking certain groups in our society. They were harsh, and some of them, as I indicated, were mean. And what you've told us was that you had a major blind spot. Those are your words. And that there has been a change. Tell me about that road to Damascus. Tell me what changed in your life that took you from an extreme, harsh point of view on the right to where you consider yourself today.
Great. I understand your concerns, and I appreciate that question. Senator, a lot of the things I wrote when I was young, 18 or 19, again, part of it was lack of maturity. Again, when you're young, you think you know everything, and not only that, you think everyone else is wrong, and you think only if I can speak loudly and everyone hears, I can solve all the world's problems that everyone else can't solve. And clearly, that's not the case. As you get older, you realize you know very little when you're young. And part of it also is, I think when you're young, you think being snarky is being witty. As you get older, I think you realize that, frankly, it comes off as insensitive or tone deaf. I've learned that. I can tell you through my life experiences in the past 25 years, there have been so many good, bad, that have taught me and shaped me, I think, into a more empathetic and caring and understanding person. Obviously the most obvious one is becoming a husband and a father. I think changes you for the better. My wife makes me a better person every day. You become more sensitive to issues. Having 2 daughters, I think you become more sensitive to issues because, just the thought that my daughters wouldn't be treated equally just, makes my stomach churn. But there have been also just other things that professionally, I've done a lot of pro bono work over my 20-year legal career, and most of them have been, for the poor and for members of marginalized groups. And that experience, you spend a lot of time with clients, it opens your eyes a lot because you know things, certain things, abstract concepts, statistics. But I remember representing an African-American individual who was beaten after a routine traffic stop, and we represented him, went to trial. And again, you see these statistics about disparities. But when he, tells you and looks you in the eye and says, that he gets afraid whenever he sees law enforcement, even if nothing happens, and that really hits you. Again, you may know things in abstract concept, but when someone tells you that, it really opens your eyes and opens your heart. So, on a professional level as well as a personal level, you learn these things as you get older. There are even, small things where, when I was a young lawyer in New York, I decided to volunteer. I love baseball, so I wanted to volunteer in Harlem teaching baseball and mentoring kids. So initially it was, my love of baseball, so I'll do that. So I took the train up to Harlem. Most kids were from South Bronx and East Harlem. And whenever I showed up, these kids, they're like 8 or 9 years old. They would come running to you with big smiles on their face. And initially I thought, these kids think I'm really good in baseball. But then you realize, the reason why they're so happy to see a stranger who has, frankly, mediocre baseball skills is that these kids don't have the support system that, so many of us have had and we've just taken for granted. And so they're just happy to see that. So when you...
So sorry to interrupt you. My time is up, and I know what you're saying is heartfelt, and I certainly understand the message. And the point I want to get to is this, and as I close, Mr. Chairman, I'll be very quick in closing. Most of us are looking for someone who is not only a good lawyer, but a good person, because your power on the bench goes way beyond the law as far as I'm concerned. I am not one of these people, and I hear it said on this committee so often I almost want to get up and leave, that this is somehow robotic law. Here's a precedent, here are the facts, well, we know what's going to happen. That's not how courts work. It's not how judges work. People bring a lot of things into the courtroom. And part of what they bring are their life experiences and whether or not they can be empathetic with someone standing before them who doesn't have a fighting chance, who couldn't afford Mr. Collins and his legal team that is obviously well respected by those who can afford good representation. And the question is whether that person has a chance before you, whether you can possibly look through that person's eyes and understand what the world looks like. And whether looking up at the bench and looking at you, they're wondering, I'm cooked. I don't have a chance here. That, to me, is what this is all about, to try to not guarantee your outcomes, but at least guarantee the thought process that is empathetic to that person and understands that their whole life may be hanging in the balance of your life experience and the values that you brought from it. Thank you, Mr. Chair.
If I could, just to build on what Senator Durham said, I'm very sympathetic that myself. So let me just give you my 2 cents worth of how I look at this. There's what you say when you're young, and there's what you do when you get here. So I always look, and it's not outcome determinative, but the ABA ratings are pretty important in terms of the professional character. Like Sotomayor said at a speech, more times than not, a Latino woman probably would reach a better decision than a white male. And everybody, oh, she's racist. No. I found nobody to suggest that when it came to doing her job as a judge, she would take that view toward the litigants in front of her. As a matter of fact, I think she's just trying to say, you know, what you said, we all have different experiences. And nobody with Kagan or Sotomayor ever suggested, as being a lawyer, an advocate, or whatever they were doing, that they were unfair to their coworkers, that they held a grudge, that they were radical in their representation. And the only thing I would suggest to the committee about these 2 gentlemen is I understand you would not have picked either one of them. No Democrat would. The people who work with you through these years have all said decent people who take a different position than I do, and ethical. So what knocks you out with me is not your philosophy on the personal side. I'm a qualifications guy. But if I really believe you're holding a grudge against something or somebody, then those are the kind of people we want to knock out. And we've had 2, and I'm going to tell you who they were. The reason I feel comfortable is because when you look at who these gentlemen have worked with, it's pretty unanimous. It's not whether I agree with them or not. They're just decent lawyers and ethical people. And to me, on the people side, that's what I'm looking for. On the philosophical side, I definitely understand that you disagree with the judicial philosophy. And that to me is, I did that with Sotomayor and Kagan, but wasn't outcome determinative for me. Senator Blackburn.
Thank you, Mr. Chairman, and thank you for those remarks to kind of put a wrap around all of this hearing. Mr. Collins, are you still teaching at Loyola, or is that in the past?
I was invited to come back. I was invited to come back again, but because of
okay. Let me ask you this. If you were teaching and you have a class in front of you, what would you advise them on their professional conduct after going through all this process that you're going through right now?
Well, I would tell them the same thing that, I would have said before, which is that, they need to understand the law, work hard, and they need to always be honest about their cases. They need to be honest about what the state of the law is, how strong the arguments are, and honest about the facts and where the weaknesses in their case may be.
Okay. I appreciate that. And I appreciate your family sitting there with you and enduring this questioning. And I know they're going to be ready to get out of here and go have lunch. They've been good and attentive. And Mr. Lee, your family there, I think your mom is probably the chief mama in charge and probably does a very good job. I've appreciated you all being here. I know you did some work at the White House with the 9/11 victims, and I know that must have had an impact on your work and on your point of view, your worldview.
Yeah, yes, Senator, and I'd started my career in New York during when 9/11 occurred, and it's something obviously if you were of age during that time, it affects you, and just the victims and people who are affected, and just the strength that you see is just so inspiring. A lot of times at work, sometimes you feel frustrated or you think it's tough, but then you hear these survivors and people have suffered so much and they're so strong. I mean, it's very inspiring.
And I would think that, coupled with the pro bono work that you have done, has had an impact on the empathy that you bring to helping people, and I would think that would impact your ability to walk in another person's shoes for a little bit. There was one case in your pro bono work where there was a death row inmate that wanted DNA tested, and I think that one was covered in the New York Times, and I appreciated reading about that. Was that your most impactful case, or was there another?
I think that was an important case because I think there were serious allegations of racial bias that may have affected that case, and obviously the stakes are huge. I think the most important impactful case in a way was representing an inmate who alleged that he had been beaten by prison authorities, and he was African American. The prison authorities were all white, and we went to trial. It was before almost all white jury, and I remember him telling me, he says, "I'm telling you the truth, but I don't know if I'm going to get a fair shake," because he's pointing to who the defendants are and the jury, and I frankly didn't know what to tell him other than we do our best, and we did win that case on the jury trial. The jury agreed with him, and and he was so happy, and he said he'll take me out to lunch once he's released. He said he'll take me out to lunch. So it was very felt good about it to have him just have a little more faith in our justice system.
And that's what you want. You want people to come before a judge and realize that they're getting a fair shake. Well, there are three things that I like to ask nominees. Will you be fair and impartial on all of the issues that you consider, regardless of your personal beliefs? Yes or no?
Absolutely, Senator.
Absolutely, Senator.
Thank you. Will you promise to put aside any bias or views that you took from a prior advocacy position?
Absolutely, Senator.
Absolutely, Senator.
Can you assure us that you will apply the law and the Constitution equally to every party who comes before you in your courtroom?
Absolutely, Senator.
Absolutely, yes, Senator.
Thank you both so much. I yield back. Thank you, Mr. Chairman.
Senator Coons.
Thank you, Chairman Graham, and thank you, both of you, for the opportunity to question and for your willingness to serve. If I might, Professor Lee, excuse me, Mr. Lee, first, thank you for sharing the story of your father's optimism and determination and his faith in our nation. One of the things that makes our system work is rules and process. And as a judge, you will be asked to enforce rules and process. And as an attorney, I'm a bit obsessed with rules and process. And as someone who used a state judicial nominating committee to consider nominees, candidates in Delaware, I was concerned with what I got in terms of a background on which articles you provided and when. I recognize that views mature over the course of a lifetime, that perhaps things you wrote in college don't reflect your views today. But I wanted to make sure I understood this because the number and the gap was pretty striking to me. Am I right that you did not provide literally dozens of articles that you yourself wrote to the selection committee impaneled by the two California senators?
Senator, the questionnaire for the Judicial Advisory Commission, I think it's question 34A.
Nominated. There were 47 writings added in January of 2019, and then another 5, and then another 27, then another 4, then another 2, then another 1. Then as recently as March 6th, 7 more articles. And part of what troubled me was hearing that these were relatively easily found by committee staff, just using public searches. Can you assure us that we now have all of your published articles, that we actually now have the full record to look at?
Senator, I believe so. Again, I've submitted over 500 pages, and I believe they are. Again, these articles were from 20 to 25 years ago, and again, pre-internet era, so most of them were not on the internet, and I didn't have a master index of everything I've written, even as a teenager, so I believed I had collected everything, and when we discovered that it wasn't, we supplemented it, and again, I apologize to the committee for the frustration it caused.
I mean, the notes I have here say that of the 45 that supplemented the initial filing, 5 of them were from the same date, same publication as other articles that were in your initial disclosure. So to me, this was very concerning. Just the number, the length, the difficulty. Look, folks who I have, who are now sitting on the bench in Delaware, commented that our questionnaire is very thorough, very long. But frankly, I think it's important to respect that process. Is it critical, in your view, for judges to be thorough and honest?
It is, Senator.
One of the things you wrote that was disclosed, and I'm just quoting, this is a college article, but you said, and I quote, "Cries of racism often stem from isolated incidents and from unreliable studies based on statistical chicanery." I don't know if I'm pronouncing that word right. Do you still stand by that statement?
Yeah, I don't, Senator. I mean, obviously, discrimination is real. You know, my family has suffered it. I think some of the language, again, that I used in college, again, when you're 18 or 19, you don't have the nuance. You know, you're trying to express a gut feeling based on your personal experiences or limited knowledge. So, you know, you don't understand the complexity of the world. And, you know, I regret some of that language that I used.
Thank you. Let's jump forward to something you wrote in 2001. So you're not 18, you're not in college, you finished law school. This was while you were a clerk. You said that, and I quote, "Left-leaning lawyers have successfully waged a rights revolution over the last 3 decades." What rights were you referring to, and what should we conclude from that?
Thank you, Senator. I think some of the things I was referring to, I think there was the mentally ill who were freed from institutions. And I think the purpose of that article, Senator, was my concern that, because I'm a strong believer in pro bono, as you've seen from my track record, and you know, most of my pro bono cases are just representing individuals who are poor or who don't have access to justice. And my concern was that if too many lawyers take pro bono cases that are politically charged or very sexy, that people would lose support. People would not support pro bono because they view it as too political. And if you also see later in that article, I mentioned that conservative groups were doing the same as well. And I was concerned about that as well, that if pro bono is seen as a vehicle just for the left or the right, the general public and the legal profession may not support pro bono because they just view it as a political tool. So that was part of my concerns that motivated that article.
If I hear you right, your argument, your advocacy here, where it seems, at least in the quote, you're arguing against a recognition of a broader understanding of rights. You're asserting your argument was, we need folks who are willing to go out there pro bono and just handle workmanlike day-to-day cases representing established rights, established claims, and not seeking to advance a particular agenda?
I don't know if I was saying it that broadly, but it was just my concern that if too many of the pro bono cases involve politically charged issues, people wouldn't support pro bono because they just view it as too political. That was my concern at that time.
Thank you. Let me ask, if I might, one question of you, Mr. Collins. You suggested in a 2002 speech that, and I think I'm quoting here, "General technological advances may legitimately have the effect of reducing the degree of privacy that existed when the Fourth Amendment was adopted." Close quote. Technology and the ability to collect personal data has not just rapidly advanced, it has changed the frontiers of virtually everything about privacy and what data can and should be collected. Do you believe an individual's right to privacy, the underlying right, the recognition of a right to be safe in one's papers and effects in the Fourth Amendment, has decreased because of these technological advancements?
No, I think the kind of point I was making, I think, is validated by for example, the Supreme Court's decisions in Riley and Carpenter, which have made changes from prior precedent in the Fourth Amendment area with respect to search incident to arrest, with respect to Smith v. Maryland, in light of the significant privacy concerns by the technological changes. So that's the kind of point I was making, and I think those cases kind of validate that intuition.
Thank you, Mr. Collins. Thank you, Mr. Lee. Appreciate the opportunity to question you today. Thank you, Mr. Chairman.
Senator Klobuchar, we have 8 minutes left on the vote.
Okay, well, then I better hurry.
Well, no, I don't want you to hurry. That's
No,
the
it's
point.
okay. I'd rather
So
just do it.
Do you want to?
I'll just do like 5 minutes
Okay,
and then
whatever.
run
But
over there.
if you need to come back,
They'll tell me if I can't make it, and I'll put the rest on the record. So,
Okay.
Mr. Collins, I know you talked about this with Senator Feinstein, but you drafted an amicus brief in a case before the Supreme Court called Hamadan v. Hamdan v. Rumsfeld, in which a detainee challenged the legality of the military commission convened to try him for conspiring with al-Qaeda. You argued that the Constitution's commander-in-chief provisions empower the president to establish military commissions. The Supreme Court disagreed. What do you believe are the limitations on the president's commander-in-chief powers in a time of war?
Well, the particular issue that we addressed in that amicus brief really just went to sort of what was the inherent scope of the authority to invoke military commissions in a sort of pre-statutory period. So we kind of went through the history, and it was primarily a historical brief going through the history of military commissions. It ultimately, given how the court disposed of the case, my brief proved to be irrelevant because the court decided.
But my question is, what do you believe are the limitations on the president's commander-in-chief powers?
I don't think it would be appropriate for me sitting here today to opine on the substance of that question. I've already learned from the chairman's comment that I've not kept up with this area of the law because I wasn't aware that the statute had specifically prohibited the trial of citizens. So I wouldn't purport to address it off the top of my head.
Okay. Mr. Lee, I understand that you worked as associate counsel and special assistant to President George W. Bush. According to an article in Super Lawyers, you were involved with the White House's response to congressional inquiries into the firing of several U.S. attorneys and helped to evaluate the assertion of executive privilege. What did you take away from that experience, and how do you think it will impact your evaluation of executive privilege in the future?
Senator, I think what I learned was the balance you have to take into account between the legislative prerogatives, and it's very important for the legislature to have oversight. That's a key constitutional role. But there's also countervailing value of being able to provide unfettered legal advice within the executive branch. So there's a tension between the two, and I think you have to balance the two. You have to learn to accommodate and try to come up with a compromise deal in those situations.
In an opinion written by Chief Justice Berger, a Minnesotan, a unanimous Supreme Court held in U.S. v. Nixon that a president could not assert privilege over materials subpoenaed in a criminal trial based only on the generalized interest in confidentiality. Do you believe that the court properly asserted jurisdiction to resolve the conflict between President Nixon and the special counsel?
Senator, I'm vaguely familiar with the case. I never read the opinion, but obviously it's an important decision, and as an inferior court judge nominee, if I'm confirmed, I will faithfully follow it.
In an article you wrote for the American Enterprise in September of 2002, you criticized the use of disparate impact claims, which allow plaintiffs to show that a policy has a discriminatory effect even if it wasn't motivated by an intent to discriminate. The Supreme Court has repeatedly affirmed that disparate impact claims are an important tool to protect against discrimination. Can you speak to how you would approach a case involving a disparate impact claim if you're confirmed as a federal judge?
Great. Thank you, Senator. Obviously, the Supreme Court in the employment context has held the disparate impact claim could be viable. I think there's a test. You provide disparate impact, then the other side has to proffer a reason to show that there were other factors involved, and the other side can show that that is pretextual. And Senator, obviously, I will faithfully follow all precedent, and you have to take discrimination claims very seriously. It's something I believe in personally as well as a racial minority, and it has to be taken very seriously.
Okay. Mr. Collins, you wrote an amicus brief in Burwell v. Hobby Lobby in which you made a broad constitutional argument that the First Amendment's free exercise clause extends to a for-profit corporation's exercise of religion. If corporations have a protected right to exercise religion, is it your opinion that corporations could also say refuse to hire someone because of their sexual orientation, or what about the religion that they practice?
The primary issue that we addressed in that case was the statutory issue about what was the coverage of person within the meaning of the Religious Freedom Restoration Act. That required some consideration of the subsidiary question of how it had been treated under the free exercise clause, and we looked at one case in particular where a corporation had been allowed to assert a claim. But I don't think it would be appropriate for me, particularly as these issues are working their way through the court, to opine on some of the open questions that I know are being litigated right now.
All right, thank you. I think I'm going to go vote, but I appreciate it. I'll do a few other questions on the record. Thank you.
Thanks, Senator Klobuchar. I think that's it. We'll hold the record open for written questions till March 20th. Thank you very much. You both led consequential, good, and decent lives. I appreciate what you've done thus far for our country, and I think in both of your cases the best is yet to come. Hearing is adjourned. Since I wrote it, that's not what I'm